Hi, everyone. Welcome. Good afternoon. I am Madelena Viksne from Samfiru Tumarkin. I'm an associate at the firm in the Labor and Employment Group, and I'm here today to answer some of your questions, if you have some, about employment law generally. First thing, I thought I would sort of start off talking about the major tech layoffs that seem to be continuing. Amazon just laid off 10,000 of its employees in the tech sphere. And it's not the first one who has done sort of a widespread restructuring or layoff sweep. Meta, Twitter, Hootsuite, Microsoft, Shopify, and Snap have all substantially reduced their workforces, apparently based on market conditions. With Amazon, they have said that they will help affected staff find new roles within the company because they fired sort of out of a specific area, and says that those who are not found a new position will get a package including separation payment, transitional benefits, and external job placement support. In Canada, if you are laid off, non-unionized employees and senior executives are owed full severance pay for losing their job through that downsizing, or a downsizing that's not at Amazon as well. If you are laid off at any time, don't sign anything. If your employer doesn't have your consent, or there isn't a term in your contract that permits them to lay you off, that layoff can be treated as a constructive termination. So it's important to not sign anything that you may be provided at the time of your layoff, and really take into consideration speaking to someone in our office or an employment lawyer generally to find out what your potential entitlements might be based on the layoff being treated as a constructive termination. If you don't want to treat it as a termination and you want to take the layoff, then under the Employment Standards Act, the employer is limited to 13 weeks if they don't maintain your benefits, and 26 weeks, I think, but I could be wrong about that. Sorry, 13 weeks if they don't maintain your benefits. I know for sure. But I just had a little moment there with my memory. Just a sec here. 35, that's the number I was looking for. 35 weeks if they do maintain your benefits. So you will have to take into consideration the fact that that layoff that you don't want to treat as constructive, assuming you didn't consent to it and there's nothing in your employment contract allowing that layoff, could be quite lengthy. One thing that I would say is that if you're concerned about potential for layoffs, I would try now, while you're not laid off, to get a copy of your employment contract. It's a really necessary and helpful thing for us to have when we're evaluating or analyzing your case, in order to best advise you. It's more difficult to get from HR or otherwise after you've been terminated or laid off. But having a copy of your employment contract available to you is quite important from a legal analysis standpoint. And just to remind you one more time, do not sign anything that you're provided until you've spoken to a lawyer. Key Sheen Petgrave from Facebook said, "What are your thoughts about employees who are working remotely through with FTX who lost all their funds? I heard they were encouraged to use FTX as a savings account." I don't know enough about that really to comment. If they were encouraged versus required to use it as a savings account, that would change the analysis as well. I think that it's really, really terrible, not only for the employees who would have lost everything, but for all of the people who lost a lot based on that situation. I'm sure there's a lot of people who are extremely devastated right now, and so I feel for you. I do not know enough about the employees working remotely who lost their money based on being encouraged to use FTX as a savings account. But if you have an article that you want to share discussing that, then I would be interested to learn more. um, Question from YouTube from Alex: what can you do if you signed a non-compete as a contract? I mean, it's going to depend on the language and the scope of the non-compete. So there's three different things that are sort of in the analysis. The first is the temporal or time span that it applies. The second is your geographic scope. And then the third would be what the actual restrictions are. Courts tend not to like non-competition agreements because it interferes with your ability to find a new job, and that's not particularly fair or equitable, and it interferes with economic relations. The time and scope should be limited to minimum, maximum minimum amount required to protect the interests of the business while at the same time respecting and allowing the employee to, seek other work. Um, if if the clause is vague or overbroad or covers the entire world, stuff like that, it'll easily be tossed out. It may require that you bring a motion. If your employer decides to enforce it, it doesn't mean that they're going to be successful. So one example that I would say is, like, if you work as a vet at an exotic animal vet clinic, so that's obviously like a bit of a niche thing. There's probably not too many of them, let's say in Toronto. Your employer probably won't be able to justify a year-long non-compete restricting you from anywhere in the GTA that deals with exotic animals, especially if that's your specialty. They likely will be able to enforce something that is, 6 months at any vet clinic that is within 5 kilometers of the original employer and deals with exotic animals. You can see how there's a difference in terms of the scope. Like something that's like all of North America, it's going to be much harder to justify than something that's like a small geographic region where direct competition would actually be sort of possible by you being there. The time should be limited, and if you're only receiving your ESAs upon termination, I would absolutely negotiate a non-compete agreement, because in my view, if they're going to restrict you from finding work within your field for any period of time, you should be paid for that time by them. That's not the law, that's not the rule, but that's sort of how I think about it. So if you're only receiving, 3 weeks pay, but they want to restrict you for a year, obviously that's completely unreasonable. You can't work in your field of expertise for 6 months, but you're only getting compensation for a very short time. That's not going to help you find a new job. So it really depends on how restrictive it is. If you have questions about your particular one, you could definitely get it read and analyzed by an actual lawyer. If you want to call our office, I'm sure somebody would be able to do that for you during a consult. I will say that non-solicitation agreements, which means the agreements that don't deal with where you're going to go afterwards for work, but rather the customers and other businesses like suppliers and stuff and other employees, and whether you can ask them to come with you or take them with you or use them at your new job and that kind of stuff. Those ones are much more likely to hold. So it may be that the non-competition is struck out for being unreasonable, but a year-long non-solicit that restricts you from taking employees, suppliers, and customers or something from your previous employer likely will be upheld. Not a guarantee, but likely. Those are much more likely, at least. One thing also, though, Alex, if you are terminated or you get terminated and you have a non-competition agreement, it is something that I have frequently negotiated out of the or asked successfully had the employer agree to waive it, I guess is a better way to phrase that, during negotiations regarding severance and sort of termination packages and stuff. you can ask them to waive it completely. You can ask for it to be revised with agreement between the parties in terms of new terms of it, to limit its sort of scope and the effect that it might have on you. It's a good idea to sort of seek out what you're looking for in the market and see if it even is going to have an impact in the time frame that your non-compete actually applies to. If you're in tech right now, based on what I said at the beginning here, if you're at tech in a job similar to Amazon or Twitter's, recent terminations, it may not be a big deal for you to have a 3-month or 6-month non-compete that applies because your ability to find one of those roles at this moment with the hiring freezes is probably very limited, and unlikely to change in the next 6 months. That's not to say you can't ask for it, but it's probably not the end of the world. If you have a year-long one in, I don't know, some sales job, and there's lots of those jobs available, but you're unable to apply to them because of it, that's a pretty good justification to present to the other side and say, listen, if I get a new job, then you owe me less. So that will be mitigation earnings, and you should probably just agree to waive this so that I can look for these jobs, or at least renegotiate it. I hope that helps. As someone who's actively JR from YouTube said, as someone who's actively pursuing and engaging employers for employment, what is your advice for proper social media etiquette if one uses certain sites like Facebook and Twitter? Don't use them, to be honest. Make everything private. Even if you believe that everything is private, it's likely not fully private, in all respects. Like, a picture or something might still show up in a Google search. But I would restrict everything to private, at least while you're seeking employment. I would consider going through your posts, especially if you tend to be someone who posts volatile things that you wouldn't want a new employer to see. Now is the time to get rid of it. It's maybe not gone forever, but at least if somebody does end up getting onto your profile, they're not going to see, whatever it is that you could be worried about. In terms of Twitter, I'm not sure that employers check Twitter. I'm not really sure who is checking Facebook either. But it's possible that they could. And that's really all that matters, is that if there's a possibility that if you're on social media, your new employer is going to find you. Create a LinkedIn profile, make it very professional, have all your information there. Unless there's some reason that they would look beyond your LinkedIn, and be trying to find your Facebook or something like that. I don't know if that's a thing that is done, but make sure that those things are private so that whatever it is that's there, is yours. You can also not make your Facebook private, but you can make your photo albums private, for instance. I just think less is more. I would also refrain from too much. I would either refrain from or minimize access to anything that's like overly political or overly controversial, in the more recent sort of, if someone scrolls. That's not to say that you're not allowed to post your opinion and say whatever you want. I get it. But in terms of the first impression, if a new employer gets your resume and they look you up and that's what they see, is it what you want them to see? Should really be the evaluation. Just being cautious and being cognizant of the fact that, a dividing topic, I guess I could say, being discussed in a very sort of forceful way, is something that maybe would put you in the no pile. But maybe it's something that would put you in the yes pile. So I guess you just have to consider based on who you are applying to and sort of what you believe they would or wouldn't care about. But I would say better safe than sorry. I would just make everything private if that's possible. But also assume that anyone can see everything that's there. So think about what's available to somebody. I was dismissed without This is a YouTube question from Willie. I was dismissed without cause in 2021 and provided severance. I got a new job and things were good. Out of the blue, my new employer received an anonymous letter, likely from my previous employer, saying I was terminated due to criminal activity. This was not true. What are my options if I'm fired because of this? um, so a couple of things to address here. You said likely from your previous employer. I'm not sure what sort of evidence or indications you have that it was in fact them, but you also need to be extremely careful in making that kind of an allegation if you don't have um, anything to back it up in regards to your previous employer's involvement. Uh, you should be cautious about making public statements about your previous employer in any event. I usually suggest that you just don't. But if you think that they are interfering with your new job and interfering with your ability to find or keep your employment, that's fine. But I wouldn't make any sort of I would be cautious about saying that without proof out loud or in public. This is obviously fine. You didn't name them, but it could just create more problems for you, um, and cause them to lash out, even if it wasn't them. Um, you said it's an anonymous letter. Unfortunately, there's not much that you can really do unless you can identify who it is. Even then, what you could actually gain out of doing it is, not really probably going to be worth your time. Um, Anything like a defamation case is extremely hard to win, um, and doesn't really have that much of a chance of success in most cases unless you can demonstrate specific losses and a number of other things. Um, and the ultimate defense for it is truth. So, if there is anything about the letter that is true, then those allegations and the truth of those allegations would um, circumvent would be a perfect defense to the claim if you were to bring one. It says you were terminated due to criminal activity. If you weren't, then why don't you go get something with the police maybe that would confirm that there was nothing? Get your criminal record check, or I don't know. Um, Go and ask your old employer for a reference letter or a letter of confirmation that says your job position name, job position, duties and responsibilities, and your um like advises that you were terminated for whatever other reason, restructuring. That doesn't refer to that, or get them to write. If you do truly think it's them, I'm sure you have some inkling about who there would have done that. So go to somebody else and ask them to write you a letter that just confirms that that is not true, or confirms the reasons for your termination if you're worried about your current employer believing the letter. If you're fired because of this, then you um, then you probably will be entitled to notice or pay in lieu of notice. Um, and if you receive a termination letter and you suspect that it has to do with this, then you should speak to a lawyer at a firm. That said, you said you were dismissed without cause in 2021 and provided severance. So presumably you received a termination letter from the old employer. That is also something that instead of going and getting a new letter from them, I missed that before. You could just share your termination letter and your ROE with your current employer and say, listen, like I'm really concerned about this anonymous letter. I wanted to make sure that it was clear to you that that was completely false. Here's some stuff that shows that they didn't terminate me for those reasons. I'm not sure how these allegations came to be, but um, I want to, make sure that you don't have concerns about that. Um, I would say, like, this sounds like, if your new employer is going to terminate you based on an anonymous letter, without having sort of spoken to you about it, without giving you an opportunity to respond, without kind of, at least questioning that, then like they're not really having your back. it seems a little crazy to me that an anonymous letter would result in any kind of termination for you, um, unless there's some way that they can either contact the person who wrote it or identify or confirm the allegations that are in there. So if what you're saying is true, that none of it is true, and you were not terminated due to criminal activity, then I don't see any problem with you sharing your previous termination letter, or something else that you decide is sufficient, and having a conversation with your current employer saying, like, listen, that really freaked me out. I don't know where that's coming from. That's not true. This is my termination letter. This is why I was terminated. And, I hope that you will appreciate and believe me, based on our relationship. I really like my job, that kind of thing. Uh, Lisa from YouTube said, as of November 3rd, 2022, I still can't get my job back. They mandated the shots August 31st, 2021, and 15 months later, still being discriminated against where other companies are bringing back their workers. What can I do? I mean, you can't force your employer to bring you back, I suppose. A number of companies have withdrawn their vaccination policies and starting to bring those employees back, with or without vaccination, but a number of companies are not. There are still mandates or policies in place, a number of different other places, I'm sure, um, where you would have to be vaccinated to return. If your employer has not withdrawn their actual policy, or repealed it, and it still does apply to your workplace, then they're probably not going to recall you. After 15 months, that's a pretty long time. It seems like maybe it's not going to happen. I'm sorry to say. Um, has anyone else been called back? Like, that's a factor that informs my sort of thoughts about this. If other people are being brought back to work at your company who were not vaccinated previously and you are not, then I would have concerns that they're not going to. If nobody has been brought back, then it could be that they're just continuing to have that policy and continuing to maintain those layoffs. Um, if that is the case, then I would suggest that you contact our office to speak to one of our lawyers, who can discuss, your options from here on. If you want to be reinstated, it depends on who your employer is, and whether you're governed by the federal or provincial statutes. But if you're governed by the CLC, Canada Labor Code, reinstatement is a potential possibility. If not, there's the possibility of alleging constructive termination, depending on the facts of the case. So it is necessary for you to talk to someone in our office, or whoever, but someone in our office will be able to help you if you want to have that call. I would say as well that it's important that you have copies of any correspondence relating to the policy, requests to return back to work, from start to finish of the vaccine policy stuff, even before the layoff, and a copy of your employment contract and any other relevant documents before you have that call, because there will be things in there that need to be reviewed. And this is going to be my last question. from YouTube asked, can you be fired for cause if you weren't provided with proper training? So that's a very broad question. um, if you weren't provided with proper training, then it is a potential breach of the Occupational Health and Safety Act on the part of the employer. Um, if you're talking about during your probationary period, the first 3 months of your employment, then you would have an obligation to be given the employer would have an obligation to make sure that you sort of have enough time to actually you know, get oriented and learn what you're supposed to be doing, and for them to evaluate you as a fit or not a fit, and give you the training that you need, and reviews and all of that, so you know how you're doing. That's actually an obligation during a probationary period before they make a decision about termination. Um, it's hard for me to say what it is you're speaking about exactly. If there was a safety violation, it would depend, I suppose, on where you are in Canada and what the policy says, and what the safety violation was. It's causes a very high threshold. It's very difficult to meet the threshold required to justify termination without notice. So from the very outset, any employer who is doing so is, running an uphill battle. um, because the onus is on them. The case is entirely the defendant's. The defendant or the company is the one who has to prove that they did have cause. You, as the employee, does not need to prove that they didn't. The onus is on them to prove on a balance of probabilities that your conduct was so outrageous and so serious that there was no option short of termination without notice, and they basically forced your hand. So that's the evaluation. It's doubtful that a single violation, depending on what it was, that relate, and where also you're alleging that you haven't been trained properly. It's doubtful that that threshold could be met. But as I said, it's very difficult for me to say that I don't have enough facts to really speak to that specifically. That's all for me today. I hope that you answered your questions. We have another live chat live stream, sorry, on Thursday at 1 p.m. Pacific time with my colleague Sandy Chen, and he can answer any further questions that you might have at that time. I hope you all have a good afternoon.